corporate labor activity after Citizens United. This presentation provides interim guidance to corporations and labor organizations that intend to engage in activity permitted by the Supreme Court's recent decision in Citizens United v. FEC. When the Commission adopts new regulations, those rules will supplant this interim guidance. Prior to January 2010, federal law prohibited corporations and labor organizations from using their Treasury funds to make contributions or expenditures in connection with federal elections. In Citizens United v. FEC, the Supreme Court found the ban on corporate labor expenditures to be unconstitutional. As a result, corporations and labor organizations may now use their Treasury funds to make independent expenditures and electioneering communications. They must, however, report their activity to the FEC. It's important to note that the Court's decision did not affect the ban on contributions by corporations or labor unions. Corporate and union contributions to federal candidates and committees remain prohibited. Shortly after the Court's decision, the Commission issued a press release to announce that it would no longer enforce the ban on corporate and union independent expenditures and electioneering communication, and that the agency would initiate a rulemaking and take other actions to implement the Court's decision. The press release also outlined procedures for corporations and unions to follow in the interim. Specifically, the release instructed corporations and labor organizations that intend to finance independent expenditures or electioneering communications to include disclaimers on their communications, to disclose independent expenditures on FEC Form 5, and to disclose electioneering communications on FEC Form 9. This interim guidance will be the focus of this presentation. The key provisions affected by Citizens United are those regarding independent expenditures and electioneering communications, as well as the reporting requirements associated with each. To begin, let's define the term independent expenditure. An independent expenditure is a payment for a communication that expressly advocates the election or defeat of a clearly identified candidate that is made without cooperation, consultation, or at the request or suggestion of the candidate. In short, these communications can expressly advocate a candidate, but cannot be coordinated with that candidate or candidate's campaign. So, as a result of Citizens United, corporations and unions may, for example, pay for television and newspaper ads that encourage voters to support or oppose a particular federal candidate, so long as they don't coordinate with that candidate's campaign. These ads must include a disclaimer that identifies who paid for the communication and indicates that the ad was not authorized by the candidate. Detailed information regarding disclaimers is available in our online brochure, Special Notices on Political Ads and Solicitations. A corporation or labor organization that finances independent expenditures must report its activity on FEC Form 5. Reports are required quarterly when expenditures aggregate in excess of $250 per election, within 48 hours of dissemination when expenditures are made between January 1 and 20 days prior to the election and aggregate $10,000 or more, and within 24 hours of dissemination when expenditures made within 20 days of the election aggregate to $1,000 or more. Like all FEC reporting forms, Form 5 is available on the Commission's website under Help with Reporting and Compliance. Filers can download and print the form, file using electronic filing software, or use one of the web forms available online. Unlike most FEC reports, 24 and 48-hour independent expenditure reports from paper filers may be submitted by fax or email. Until the Commission completes its rulemaking and develops new forms, filers must use the existing version of Form 5 that includes certain fields that are no longer applicable. For example, on line 2, it's no longer necessary for corporate filers to indicate whether they're a qualified nonprofit corporation. Nor are they required to certify that they're qualified nonprofits when signing the form. Detailed information regarding the sources of funds used to finance independent expenditures and the actual expenditures made appear on Schedules 5A and 5E, respectively. Corporations and labor organizations can also now use Treasury funds to finance electioneering communications. Electioneering communications are broadcast, cable, or satellite communications that refer to a clearly identified candidate, are publicly distributed, are distributed during certain time periods before an election, and are targeted to the relevant electorate. Examples might include lobbying or issue ads that mention a federal candidate and air in that candidate's district within 30 days of the primary or within 60 days of the general election. Like independent expenditures, electioneering communications must include a disclaimer identifying who paid for the message and indicating whether it was authorized by a candidate. Electioneering communications that aggregate $10,000 or more must be reported on FEC Form 9 within 24 hours of public distribution. Form 9 is available from the same section of the FEC website as Form 5. It's available both as a downloadable paper form and as a web form for online filing. Unlike most FEC filings, 24-hour electioneering communication notices from paper filers may be submitted by fax or email. Until the Commission completes its rulemaking and develops new forms, filers must use the existing version of Form 9. Qualified nonprofits and corporations and unions making communications exempt under existing regulations should check box C or D as appropriate. Other corporate labor filers will check box 6E and identify themselves as a corporation or union. Detailed information regarding the sources and amounts of funds used to finance electioneering communications and the actual payments for the communications will appear on Schedules 9A and 9B, respectively. Additional information regarding the Citizens United decision and the Commission's response to it is available on our website under Help with Reporting and Compliance, Law and Regulations, and Recent Developments. Should you have questions, please call our toll-free information line at 800-424-9530 or email us at info@fec.gov.